This is our last screenshot video for the contracts course. We're in weeks 13 to 14. This is on Chapter 9, Breach of Contract and Remedies. We're going to dispense with Chapter 10, which is e-contracts. I encourage you to take a look at it. I think it's interesting, but I want to stick with the nitty-gritty stuff for the course, and this is our last, if you will, nitty-gritty topic. If you were to look back on the course, we certainly looked at how a contract is formed, the essential elements of a contract. We looked at different problems that could arise regarding the concept of agreement, be it mistake of fact, fraud, etc. We looked at what contracts need to be in assigned writing. We looked at, in the last chapter, various ways in which a contract can be discharged. It may well be, though, that a party to a contract is going to reach the perception that the other side rendered performance that is so substandard that it's a material breach of contract. We talked about substantial performance, which constitutes a trivial deviation from the full performance, and it doesn't entitle the party to not make payment who receives substantial performance. We had a quiz where I asked you about it, and I've got an explanation for it that I will be posting soon. In any event, here we're looking at a material breach of contract. What are the remedies? And I've divided them, really distilling Chapter 9, right? So I've divided remedies into two different categories: damages, which means monetary damages, and then equitable remedies. So let's start out with damages. In the law of damages, and actually I don't think they teach it anymore, but when I went to law school a while back, there was a course just on damages, which was a terrific course. I wish I had taken it. The problem in taking topical stuff, I remember taking a course in environmental law and thinking it was just so cool, and it was. The problem is, over the years, guess what happens to environmental law? So much of it is legislation. It just changes radically. Where the law of damages isn't that much different today in 2020 than it was in 1900. It isn't that much different today than it was when I was in law school, which was a bit more recent than 1900. But when we look at the law of damages, we see compensatory damages and punitive damages. Compensatory damages are intended to make the damaged party whole, with a W, please, and punitive damages are designed to punish the wrongdoer. Under the law of contracts, only compensatory damages and not punitive damages are recoverable. Now, sometimes a contractual transaction can give rise to the claim that one of the parties engaged in fraud. They fraudulently induced the other party to enter into the contract. So in that instance, we may not only have a breach of contract, but we may have a claim under the tort of fraud. And if it's a particularly outrageous type of fraud, and we're in tort law, then we may recover punitive damages. But if it's a straight breach of contract case, no punitive damages are recoverable, just compensatory damages, which raises the question, well, what are compensatory damages? And compensatory damages seek to compensate the non-breaching party for the loss of the bargain. And they are limited to damages actually sustained and proven to have arisen directly from the loss of the bargain caused by the breach. Full stop. So I'm going to sell you my house for $200,000. We've got a nifty contract in writing signed by both of us that says that. You breach the contract. In other words, you refuse to perform even though you got the financing and even though there's nothing wrong with the property, etc. Well, you're in breach of the contract. What are my damages? Well, we're going to probably have to wait and see what I can sell the house for. So let's assume I put the house back on the market and I'm only able to sell it for $170,000. So my damages would be the difference between what you agreed to pay for the house, $200,000, and what I was eventually able to fetch for the house on the market, $170,000. So we're $30,000, and there would be a few other items of damage in there, some expenses that I had to incur in anticipation of you buying the house, etc. But the basic claim would be for $30,000. Now, it may well be that your breach of the contract caused me emotional suffering. Question, can I recover for emotional suffering? And the answer is nope, not under a breach of contract claim. In a personal injury case, that sometimes is the largest item of recovery, pain and suffering. But a breach of contract, no emotional suffering. I might add, there's no emotional suffering under fraud, even though you can get punitive damages. Just sort of wanted to throw that in because I've been involved in quite a bit of fraud litigation over the years. To get an even more specific look at compensatory damages, you can check out 138, 139 of the book we're using, where we see the measure of compensatory damages differs to some extent by the type of the contracts. There's something also known as consequential damages, which again are monetary damages, and that's damages going forward. And a big area of that is lost profits. And I remember once representing a person who was part of a development team, and they kicked him out, and there was a breach of contract, and we were able to recover for the loss he sustained by getting kicked out of the development group. But we also wanted to recover what profits or his share of profits he might lose in the future. And that's an item of consequential damages. And to establish that, we had to show that when the parties entered into the contract, they understood that lost profits could be an element of damages. And that's a difficult item. We were not able to meet that standard, I might add. Okay, then there's another item of damages known as nominal damages. And nominal damages are nominal, meaning they're next to nothing, and they're awarded when there is no actual damage or financial loss. They are I love this word, trifling amount, such as $1. What could happen is that you can establish there's a breach of contract, you can't show any damages, in which case I don't know why we're in court, because I don't think too many people are going to want to pay our hypothetical law firm money to go through a case, and at the end for us to report to them, well, you paid us, I'm just making up a number, $25,000 in legal fees, but we won the case and here's your dollar. So I don't think we're going to run into nominal damages, but it's mentioned in the book and it's something we should know about. We can also have, and this is something a lot more practical, liquidated damages. And you might remember when I talked about performance, I talked about how you might want to put a penalty provision in a contract so that for every day the gazebo wasn't built, the contractor is losing X percentage of the contract price. That's an example of liquidated damages, which is a provision in a contract that specifies that a certain dollar amount is to be paid in the event of a future default or breach of contract. For liquidated damages to pass muster in court, the liquidated damages must be reasonable in context, and if they appear out of proportion to the actual damages sustained, then the court will not allow them. So that's our summary of monetary damages. Now we have non-monetary or equitable remedies. Historically, these remedies emerged from the courts of equity in England, and then in the colonial experience, and then in the early days of the Republic, and they still are in place today. And when we're looking at an equitable remedy, we're in all likelihood looking at a situation where monetary damages a court can conclude will not be sufficient. And the one I want to talk most about, I talk about rescission, which we've been talking about throughout the course, which is, for example, a contract procured by fraud, you can rescind it, get your stuff back, and you're done. You don't have to show monetary damages. You're just seeking restitution and a return to the status quo. But the one I want to talk about is specific performance. And that's a judgment from a court that requires a contract to be performed. It's typically limited to instances where monetary damages are not adequate, and is going to be applied for the contract of sale of unique property, such as painting or land. And you might say, my uncle lives in a cul-de-sac and every house looks the same. How is that unique? Well, in the law, every parcel of land, whether it's on the ocean or in a cul-de-sac or on my street, is considered to be unique. And the specific performance is going to be, I don't say it explicitly, and I should have, it's going to be for the buyer. So the buyer, remember I said I sold a house for $200,000? And let's assume it's not the buyer who breaches, but I breach. Even though I should perform, I don't. The buyer probably, if the buyer wants to, can go to court and get a judgment against me where the judge is going to require me, or the judgment from the court is going to require me to sell the property. Could be a painting, and I'm not thinking of a Velvet Elvis, but I'm thinking of an original painting. And certainly if we're thinking of a, Picasso, I just was looking at some artwork of Bob Dylan, and he's actually quite a interesting artist. But those are originals, and if I contracted to buy a Bob Dylan painting and the art dealer then breached the contract, I could get specific performance, I'm certain. The last remedy is reformation, and that's where we have a fraud or mutual mistake, and if it can be fixed, then the court will itself redraft the contract. Sometimes it can't be fixed, and I would just refer you to page 145 of the book. That's it. Thank you.